In 2 Corinthians chapter 3 and verse 17, we read, "Where the Spirit of the Lord is, there is liberty." So in Lecture 8 now, it's our intent and our hope that you're going to be able to understand the historical background of the Bill of Rights, including those arguments favoring and opposing the adoption of the first 10 amendments to the Constitution. And also we desire that you're going to be able to understand the purpose and the function of the First Amendment and the restrictions that it places on the federal government. With Lecture 8, here's Jake McCauley.
Thank you for joining us for Lecture 8, where we're going to discuss the Bill of Rights and the First Amendment. And before we do that, I'd like to lay a premise that historically speaking, Englishmen felt it was their duty or a necessity to reassert their God-given rights. One of the ways they did this was through the Magna Carta in 1215 with King John at Runnymede. We also have the Englishman's Bill of Rights in 1689, which reasserted the true, ancient, and indubitable rights and liberties of the people. Now, many of you may not know this, but in the original Constitution, there was no Bill of Rights. Why, one might ask? Well, James Madison thought that a Bill of Rights was unnecessary because the document itself only expressed or delegated certain powers to Congress. So why do we need to limit them? We've only told them what to do. They can do no other. Alexander Hamilton also thought it might be dangerous to have a Bill of Rights because how could one possibly list all of their God-given rights? And if we forget one or two or a handful or a dozen, the government may come in and say that it has authority over those particular rights and it has the ability to delegate whether we can have it or not. But many people wanted a Bill of Rights. A lack of Bill of Rights was the principal objection of the Anti-Federalists. These were people that were opponents of the Constitution, men like Patrick Henry and George Mason. Writing from France, Jefferson thought that the Constitution was good, but he regretted that it lacked a Bill of Rights. During the ratification debates, the Federalists, who were the supporters of the Constitution, promised a Bill of Rights if the states would ratify the Constitution as it was. Now imagine that. Trust me. I don't know if we would have the same faith and confidence in our leaders in this day and age that they did then, but the state ratifying conventions proposed about 350 amendments after the Constitution was ratified. They kept their word. Many of them duplicated each other, so Madison worked all of those 350 into 12 amendments and introduced them to Congress in 1789. A congressional committee then reworked these amendments and passed them. The necessary 3/4 of the states ratified the first 10 amendments in 1791. They became known as the Bill of Rights. Madison's 11th Amendment dealt with congressional reapportionment and was never ratified. However, his 12th Amendment dealt with congressional pay raises and likewise did not receive much initial support, but later on in recent years, the amendment was renewed and it was finally ratified by 3/4 of the states in 1992, becoming the now 27th Amendment. Each of these first 10 amendments, it's important to understand, limited federal power. Many of the remaining amendments have expanded or aggrandized federal power, and that's interesting to understand because the philosophy of our founders and the philosophy of those who are currently in government is changing. Initially, the Bill of Rights limited only federal government, but it did not limit state or local governments. However, recently the courts have ruled through what is known as the incorporation doctrine that the Bill of Rights are incorporated into the 14th Amendment and thereby applied to the states respectively. Now, moving into the actual Bill of Rights themselves, we start with the First Amendment. Congress shall make no law respecting an establishment of religion. This deals with religious freedom and other freedoms. There's 5 essential freedoms in this First Amendment. That first phrase sets up a jurisdictional separation of government, the state or Congress from the church or religion. This illustrates a biblical concept of religious freedom. In the Old Testament, kings, you see, would always come from the tribe of Judah and priests from the tribe of Levi. This is a great example of separation of church and state. The two would not cross over into each other's jurisdictions. In the New Testament, Christ said, "Render unto Caesar what is Caesar's, and unto God what is God's." In other words, he's limiting the power of Caesar, and then he's also separating that power and making it distinct from the power of the church. The civil government derives its authority from God. In Daniel 2:21 it says, "And he changeth the times and the seasons. He removeth kings, and setteth up kings. He giveth wisdom unto the wise, and knowledge to them to know understanding." In fact, all law is based upon moral values, which have their roots in religion. The statement, "you can't legislate morality," is silly, because every piece of legislation tethers itself, it ties itself to a morality. The question isn't whether or not we can legislate morality, it's whose morality will we legislate. To quote R.J. Rushdoony in his book Law and Liberty, "We may disagree with the morality of a law, but we cannot deny the moral concern of law. Law is concerned with right and wrong. It punishes and restrains evil and protects the good, and this is exactly what morality is about. It is impossible to have law without having morality behind that law, because all law is simply enacted morality." The colonial charters acknowledged God as the source of governmental authority, and many had state churches. Now, these were Christian churches, and this was the Christian God. New England colonies like Massachusetts, Connecticut, New Hampshire, they established congregational or Puritan churches. In the southern colonies, you had Virginia, North Carolina, South Carolina, and Georgia. They were the established Church of England, or the Episcopal Church. In the middle colonies like Delaware, Rhode Island, New Jersey, Maryland, and Pennsylvania, New York, they often had greater degrees of religious freedom, but still publicly recognized God, and often required citizens to affirm Trinitarian faith to vote or to hold office. Between the years of 1620, when they landed at Plymouth Rock, in 1789, the American culture moved more towards religious liberty for several reasons. One reason is Puritan thinkers like John Bunyan and John Milton. It was also the First Great Awakening, which was the Christian revival in the 1740s, which led many to leave the established Church of England, the Episcopal Church, and join dissenting churches, like Presbyterian or Methodists or Baptists. They then objected to supporting the Church of England. Madison, Henry, and others defended Baptist ministers that were preaching without an Episcopal ordination. This led them to press for religious liberties in Virginia. The threat of an English archbishop being imposed on the 13 colonies was a serious concern for the founders. But perhaps most importantly, the question was, which church would be the established church of the United States? The many different churches and establishments in the various colonies led to the agreement that the establishment of religion should be a state matter and not a federal matter. Now, I want to establish the true meaning of the Establishment Clause, while at the same time debunking two historical myths about Thomas Jefferson in relation to this clause. We hear that phrase being thrown around quite flippantly with random meanings that people want to attach to it. The separationist view of this is that there's a wall of separation between church and state. Now, Jefferson penned these words in 1803. This was 14 years after the First Amendment had been ratified. It had no bearing on the First Amendment. As a matter of fact, Jefferson was in France when the First Amendment was drafted, so he wasn't even present. In a letter to the Danbury Baptists, Jefferson wrote that he saw the wall of separation as protecting the church from the state, the exact opposite of what is taught today. Jefferson's words virtually were forgotten for 150 years, but now they're quoted out of context as though they represent the true meaning of the First Amendment. A better view is the non-preferential treatment view. Madison's explanation on the floor of Congress was that he apprehended the meaning of the words to be that Congress should not establish a religion and enforce the legal observation of it by law, nor compel men to worship God in any manner contrary to their conscience. This doesn't stop men from worshiping, it just cannot compel a man to worship. Justice Joseph Story wrote in his book Commentaries on the Constitution. Now take note, he was a Unitarian, so this is a very unbiased view of our founders. He said, probably at the time of the adoption of the Constitution and of the amendment to it, now under consideration, The general, if not the universal sentiment was that Christianity ought to receive encouragement from the state, so far as was not incompatible with the private right of conscience and the freedom of religious worship. An attempt to level all religions and to make it a matter of state policy to hold all in utter indifference would have created universal disapprobation, if not universal indignation. He went on to say the real object of the First Amendment was not to countenance, much less advance Mohammedanism or Judaism or infidelity by prostrating Christianity, but to exclude all rivalry among Christian sects and to prevent any national ecclesiastical establishment which should give to a hierarchy the exclusive patronage of a national government. Now, we've just discussed what our founders' view was of the Establishment Clause. But courts, beginning in 1971, rather than taking the founders' view on this subject, have begun creating tests by which they are the ultimate arbiter of who passes or fails that test to determine what is against the Establishment Clause. The courts have taken on a new ideology. They have turned original intent on its head, and they're redefining church as any religious activity versus a denominational preference. And I want to share that here with the Lemon Test, which was created in 1971. Statutes must have a secular purpose. However, that does not mean that they may not have a religious purpose, but its primary effect must not be to advance or inhibit religion. It could be an effect, but it can't be the primary effect. It must not constitute excessive entanglement of government with religion. In other words, it can have some entanglement, but not excessively. The Lemon Test is the framework for an analysis, but it's not necessarily an ironclad rule. Justice Scalia commented on this. He said, "When we wish to strike down a practice that it forbids," speaking of the Lemon Test, "we invoke it. When we wish to uphold a practice it forbids, we ignore it entirely." Through the decision of the Lemon Test, the Supreme Court ignored the simple language, "Congress shall make no law establishing a religious denomination." And they basically rewrote the law into virtually muzzling religious activity. And this, of course, is according to their ever-changing whims. The practical effect of the court's invoked tests, and I want you to pay attention to this because this is very important. It's kind of acting as a judge's relief act, because what authority is the court really assuming when it utilizes various tests? Remember, they create the test, and then they come up with the conclusion of the test, and they determine if you've passed or failed the test that they've created. By making itself the final arbiter of the meaning of words, what the court has essentially done is declared itself to be divine. Because we understand, as our founders understood, that law comes from God. We move on in the text, or prohibiting the free exercise thereof, or of that religion. Exercise implies words and actions, not just conscience, such as school plays, student essays, erecting monuments in parks, and things of that nature. It seems that China would have freedom of religion as well, or certain communists or dictatorships would have freedom of religion. You just don't have the ability to exercise it. That was the difference between the American colonies and those oppressive regimes. The Supreme Court came up with another test to determine if free exercise was being violated. This was called the Yoder test, and this was in 1972. And the questions are, does the individual have a sincere religious belief? This test is clearly outside civil government's authority. An individual's thoughts are not subject to government regulation. Does government action impose substantial burden upon the exercise of religious belief? Substantial being the key word there. Does government have a compelling interest that cannot be achieved by a less restrictive means? There's also the Oregon versus Smith test, and this is only dealing with religion. And then there's the rational basis test. So this is a test before you can take the test. Why not Congress shall make no? It seems to me that that's much simpler, and it's more in line with what the founders originally intended. we move on with the phrase, or abridging the freedom of speech. The reason that the founders made that clear was because the English Bill of Rights held that only Parliament had freedom of speech. These were the elected representatives, but the individuals themselves, the individual citizens, did not. The general principle is that speech is protected, but states which ratified this First Amendment had similar provisions in their state constitutions, yet they prohibited blasphemy and obscenity. So there is limits here. There's certain forms or expressions of speech that are not under the protection of the First Amendment. Speech presenting clear and present danger, for example, to national security or public safety is prohibited and not protected. Speech soliciting crime or violence, fighting words, obscenity, defamation, those are examples of speech that's not protected by the First Amendment. However, we do have to understand that in this concept of freedom of speech, we may have the freedom to express our views in our speech, but others have that same freedom and liberty, even though we may disagree with them. The First Amendment continues with, or of the press. On the Potter-Stewart view, this clause gives the press special protection or preferred status as a check on government power. But Warren Burger, in his majority view, this clause gives the press no special status or protection. It simply extends to the press the protection of free speech that the individuals already have in America. Or of the right of the people to peaceably to assemble and to petition the government for a redress of grievances. The king's insensitivity to the colonists' grievances was one of the factors leading up to the Declaration of Independence. The public presentation of grievances can be a safety valve against, for example, violence. There are many modern-day examples of peaceable assemblies, such as the 2009 Tea Party gathering in Washington, D.C. Protests that involve rioting or property damage are not peaceable assembly and therefore are not constitutionally protected. Participants in such protests are breaking the law and should be arrested accordingly. In conclusion with this lecture, I want to make sure that each of you reads that letter of Thomas Jefferson to the Danbury Baptist to better understand what he was stating when he made the statement, wall of separation between church and state. Thank you so much for joining us.